I didn't know.
All right, Judge, thank you. That's all I have.
Thank you very much.
See you next week.
Deontay Wingate.
Good morning, Your Honor. Sean Lapella for the record.
Good morning.
Judge, we filed a motion to dismiss and a motion to set bond, which is both set for today. I understand the state has an objection to our jurat on our motion to dismiss. It's basically the same jurat I've been using for 15 years. When we have issues like where the
Sounds like for
defendant-
15 years it was done incorrectly.
When we have issues, Judge, where you have to be sworn on a C4, and the person might not have personal knowledge of that particular situation, but we're gleaning the facts from the police report and the facts that would line up with the state's
I
best
understand.
case.
Do you disagree with the Supreme Court decision they cited? It was a pretty.
I'm not disagreeing, but basically the case law says that we can swear them to the facts, and then the state said that they're going to file a traverse, and they can do that. But I can swear them to the facts on the record, if the court would allow me to do that, which I think the case law says is okay. And then the state can file a traverse if they'd like to.
Judge, I do have the order on the state's motion to strike the defendant's motion to dismiss. I think the first step would be for the court to make a decision on the motion to strike. And then after that, I have no objection if defense counsel wants to swear him under oath properly or to resubmit the sworn motion to dismiss from the defendant.
And actually, he can swear right now before the court. On the
Court will grant
court
the
now.
motion to strike.
May I approach with the order?
You may. Would you want to swear? You want me to swear your client?
Sure, Judge.
So, Mr. Wingate, would you please raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God? Counsel?
Mr. Wingate, have you read the motion to dismiss? All right. And do you swear under penalties of perjury and declare that you've read it and that the facts stated in it are true?
Yes, sir.
Any
That
objections?
satisfies the rule, Your Honor.
Okay. What's the state's position?
Judge, based on the properly sworn now motion to dismiss, I have prepared a traverse that I can file in court today. I have denied some of the material facts that the defense has alleged, and according to Bowler v. State, a motion to dismiss under subsection C4, which is what defense counsel brought this motion under, shall be automatically denied if the state files a traverse that with specificity denies under oath the material fact or facts alleged in the motion to dismiss. Here, the state has also provided additional material facts that will establish a prima facie case. So I can either file that now in court and have the judge, Your Honor, automatically deny it, or I can file it through the e-filing portal.
It's
If
filed
you want
under-
to, if you want to review it, I mean, we're kind of doing this kind of on the fly, but if you feel like there's a legitimate basis to kind of discuss this at a future date, you can.
Can I respond, Your Honor?
You can?
First of all, it's a little bit precarious with the court granting the state's motion to strike before we can have them sworn in. for a couple of reasons. One is we filed it under subsection B and C4, which we're challenging the probable cause for the basis of the arrest, which is 3.190B and also 3.190C4, which the state was objecting to on the basis of not being sworn. A B motion does not have to be sworn. So that's one of the issues. Now that the motion, the court has stricken the motion, is there even jurisdiction for the court to hear the motion without it being refiled, unless the court allows us to orally amend the motion, and then it be basically resubmitted and pertinent to the
Good.
court's
Why don't you
jurisdiction.
refile it, and then we'll address it in the next hearing. If you want to put it
Understand,
on, we
Judge.
can put it on for June 9th if you want.
Judge, could we set it for the 26th?
Sure.
And understand that is a B motion and a C4 motion, and very well. And then we have the bond hearing, Judge. We filed a bond motion, same issues that are laid out in the motion to dismiss, which seriously challenges the state's basis for probable cause based on the issue of constructive possession of a controlled substance. We understand that it's a VOP, doesn't have a right to, express right to a bond, but considering the facts of the case and the situation, and with the co-defendants, and the facts that were actually actually mentioned in the co-defendant's report and not mentioned in my client's report, about social media accounts of Mr. Toomer, who was the co-defendant, indicating that he was interested in marijuana and cough syrup. I think that's interesting. It's interesting also that it was left out of my client's report. In fact, it's fascinating, actually. But we think that there are grounds, based on the totality of circumstances, for this court to consider a bond for Mr. Wingate's case.
What's the current bond?
No bond.
No bond.
Judge, Mr. LaPella mentions that this was left out of his client's report. There was actually an amended discovery exhibit filed on May 16th. This case is only a month old. The new law violation is only a month old. The law enforcement officers downloaded this defendant's phone. There was 6 pounds of marijuana sitting in the floorboard of the seat that the defendant was sitting in. There was also a bottle of prescription cough syrup in the actual seat that he was sitting in. A phone download revealed that the defendant had multiple pictures advertising the sale of these cough syrups and large amounts of marijuana. There were also selfies of this defendant. He took a picture of his driver's license. There was also firearms located on photos on his phone hours before he was detained by law enforcement. So those photos are definitely enough to establish a connection, a nexus between the defendant and the drugs that he's charged with. He's also, when he was arrested on the new law violation, he was on probation for 4 different cases, on arrests for 4 different dates. One of those violations of probation was originally a trafficking case that was pled out to a lesser of sale and manufacture or deliver, and that's an F2L5, but he's in another case. He was on trafficking. He also pled out to sell, manufacture, and deliver. So this is a person who's been let out 4 different occasions, and he was let out for a fifth time, and here we are. So I would ask that the court deny the bond request and leave the bond at 0 based on the fact that he's not entitled to a bond on a violation of probation.
If I could just briefly respond to that, Judge. States submitted a amended discovery exhibit on May 16th, which is 2 days ago. And in that, there's an updated offense report in it, which I'm assuming is because the state reached out to the sheriff's office and said, we need more facts because there's not a sufficiency of evidence to convict this person. So they're looking at trying to add more things. If there's pictures on my client's phone that have illegal substances on them, doesn't mean that he's possessing those substances. That's not a crime. If it was child pornography, that'd be a crime. But if he's got pictures of drug contraband, that's not a crime. So I think the fact that there's an updated offense report is indicative that there's an issue with, like sufficiency of evidence, basically. I've not had a chance to review every last bit of this amended discovery. But I can assure the court that I'll have to do that, and I don't see anything that would change our position as far as the bond goes. I think he's still entitled to it based on the lack of evidence issues.
And if I may add, Your Honor, he does score 30.75 months in the Department of Corrections at this time. He does have several misdemeanor priors as well as drug priors, which is bringing his score to almost 31 months in prison.
Court will deny the motion to set bond. We'll come back and look at the motion to dismiss the next hearing.
Thank you, Judge. It's set for the 26th then?
26
9
in the
o'clock?
morning. Yes.
Thank you, Your Honor. That's all I have.
And Your Honor, I have made an offer in this case of $11.29. On 5/26, if the offer is not accepted, the state will revoke the offer.
Okay.
Okay. Thank you, Judge.
Thank you. Thomas Lockwood.
18 months. Vacation withheld still? Nope. Vacation
Days. Please. Approach, Your Honor.
You may. Thank you.
Judge, Mr. Lockwood's going to admit that he violated his probation in case number 2020 CF 372. The agreement with the state and the defense is that he'd be adjudicated guilty, sentenced to 60 days in the Okaloosa County Jail with credit for time served, and the court will revoke and terminate the probation that he's on. He'd have to pay whatever the applicable costs are. I don't know if they're $100, but then he'd have whatever they are plus a $150 legal assistance fee.
And is the defense in agreement with regards to the score sheet?
Yes, sir.
Is that the state's in agreement on the
It
offer?
is, Your Honor.
Okay. Mr. Lockwood, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
Okay, you heard your attorney state the terms of your plea agreement, and I see that there's, the plea agreement is set forth in the plea and sentencing agreement. Have you reviewed this plea and sentencing agreement and gone over it in detail with your attorney?
Yes, Your Honor.
Had all your legal questions answered?
Yes, Your
You
Honor.
understand that by entering this plea, you're waiving the right to go to a trial and to contest this, and you got a good attorney, fight this thing?
Yes, Your Honor.
You believe this is in your best interest?
Yes, Your Honor.
Okay, and that by entering this, you'll be sentenced to 60 days in the Okaloosa County Jail, credit for time served.
Yes, Your Honor.
Okay, very good. Based upon that testimony, the court will accept your plea agreement and will sentence you according to the plea and sentencing agreement, specifically the 60 days and the other matters contained within this.
Thank you, Your Honor.
Court's revoking and terminate the probation.
Yes, revoke and terminate probation. So when you get out, you don't have to, no further probation, so,
Thank you, Your Honor.
thank you.
Thank you, Judge. I think
Thank
that's all
you.
I've got.
Okay, Mr. Nopes, have a good day.
Outstanding money for collections.
I'm sorry, yes,
Outstanding money.
yes, thank you.
Thank you.
Brittany Brannon. Good morning, Ms. Etheridge.
Good morning, Your Honor. Casey Etheridge for Brittany Brandon. We're here in 2020 CF 2958. And she would like to accept the state's offer, Your Honor. She just needs to sign it. Okay, so the sentence, Your Honor, is, she would like to withdraw her denial and enter a plea. And it would be adjudication of guilt, revoke and terminate probation, 90 days in county jail with credit for all time served, $100 cost of prosecution, $150 public defender fees, all fines, fees, and court costs reduced to judgment, and the restitution reduced to judgment. May I approach?
May, thank you. Is the state in agreement?
Yes, Your Honor.
And the defense in agreement on the score sheet?
Yes, Your Honor.
Okay. Ms. Brandon, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You heard your attorney state the terms of your plea agreement, and I see that it's also contained on this plea agreement that was just handed to me. Do you understand the terms of the plea agreement?
I believe I comprehend it, yes, sir.
Okay.
90 days, and then when I complete the 90 days of county time, my probation is no more.
That's correct. It'll be, they say revoked and terminated is the technical language, but right, you won't be on probation when you get out. You will get credit for time served. This is an adjudication of guilt, and the 90 days in the county jail, you will get credit for any time served.
I don't know how many days.
And I don't either. So whatever that is, they actually calculate it at the jail. So, but I just want to make sure a lot of people have that question, and make sure
Yes,
they
sir.
get credit, and you will get credit for time served. You understand that by entering this plea, this is the final resolution, you're waiving the right to go to a hearing, a contested hearing, you've got, experienced legal counsel, you sure this is what you want to do to resolve this? Make sure you understand what I'm saying. I'm saying by entering this plea agreement here today, okay, as you come in here today, you have a violation of probation. You have the right to go to a hearing on that, right? To say, no, I didn't do any of this. Okay, I'm contesting this. I'm going to go to a hearing. By entering this plea agreement, you're waiving that right. It's a constitutional right
Oh, okay.
to go to a hearing and force the state to prove their case, right?
Right.
I just want to make sure that you understand that you're waiving that right
Oh, okay, yes,
by
sir.
entering this plea agreement.
Yes, sir, I'm waiving it.
Okay, you understand what that is.
Yes, sir, I do
And
not.
if you had all your legal questions answered about this plea agreement or anything else regarding this?
Yes, sir.
Okay, you feel like you've gotten good legal representation on this issue?
Yes, sir.
Okay, very good. Based upon that testimony, the court will accept your plea agreement. The court will enter the adjudication of guilt, 90 days in the county jail with credit for time served, revoke and terminate probation, all fees and costs, as well as the restitution. Do we have a restitution number?
The violation of probation, the only thing that I see is,
It says restitution.
yes, there was a cost of transportation on the first VOP, on the one prior to this, to the sheriff's office, 169.68. So as for the restitution that was ordered on the underlying case, if there was any, I would just ask that it be sent to collections. But if there was restitution reserved on the underlying, I'm sure the period has passed, so we're obviously not seeking restitution on the underlying case at this point. If it hasn't been done by now.
All right, I'm sorry, you got me a little confused. So there's no restitution, we should just cross that off, right?
If there is restitution that has previously been ordered, I would ask that it just be sent to collections.
Okay. Okay,
That we had agreed to as part of it.
okay, very good. Okay, very good. Thank you very much.
Thank you, sir.
Thank you. Matthew Gray.
Casey Etheridge from Matthew Gray, and we're here in 2019 CF 3446. Your Honor, we would like to deny it. For now, Your Honor, we'd like to pass this to another date so I can speak to Mr. Gray.
Very good. When do we want to come back?
Yeah,
When would you like to, in June 9th?
that's fine, Your Honor. That'll give me more time.
June 9th. And that'll be without subpoenas in the morning.
Yes, Your Honor. Thank you.
Justin Kelly.
AC Etheridge for Mr. Kelly, and we're here in 20 CF 2466. It's right over, it's 13 months. This is the minimum, so it's.
Ms. Etheridge, if you
Okay.
need a little, no, seriously, if you need a little more time, you want to speak with your, if we, during,
Your
when
Honor,
we
we
take
had
a
talked
break, you
about-
want to take a, I don't want to rush you is what I'm saying here.
Yes, Your Honor. And we had spoken about the case before. There was just something he wanted me to relate to the state, and I was letting them know that they said no. So that was the,
Okay, I'm just fine, I just want to let you know that I don't want anybody to be rushed here. This is important decisions.
this is the. Okay. What do you want to do? Okay, okay.
I'll take it.
Well, what do you want to do?
I'll take it.
Okay, you don't have to, I'm just. Okay, yeah. He'd be withdrawing his previous entered denial and admitting to the allegations in the affidavit. The terms would be adjudication of guilt, revoke and terminate probation, 13.425 months in the Department of Corrections with credit for all time served, $100 cost of prosecution, $150 public defender fees, and then reduce all fines, fees, and court costs to judgment. 1 second, Your Honor.
It's a state in agreement.
That's correct, Your Honor.
Is the defense in agreement on the score sheet?
Yes, Your Honor. May I approach?
Mr. Kelly, would you raise your right hand, sir? Do you swear or affirm the information thank you, you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. I'm looking at the plea and sentencing agreement, and based on that and based on your defense counsel's rendition of the plea agreement, is that your understanding of what the agreement is here today? The core, obviously, is the 13.425 months in DOC with credit for time served. You understand that? It's the core. You will have probation revoked and terminated. That basically is a fancy way of saying that when you get out, you don't have any further probation. Okay? Court costs and everything else will go to judgment at this time. Okay? Is that your understanding of what the plea agreement is? And you understand that by entering this plea agreement, you're waiving the right to go to a trial to contest these matters.
Yes, sir.
Have you had I noticed you were talking with your attorney before. Have you had a chance to kind of go over this with your attorney?
Yes,
Have
sir.
you read the plea and sentencing agreement closely to make sure any questions you have been answered?
Yes, sir.
Okay. Very good. Based upon that testimony, the court will accept your plea agreement and will sentence you to the 13.425 months in DOC along with the other matters that are contained in the plea and sentencing agreement. Good luck. You will get credit for time served. Bradley Kovarik, if I stated that correctly, Kovarik.
Casey Etheridge for Bradley Kovarik, and we're here in 21 CF 2021 and 21 CF 3026. And Your Honor, we'd be entering a denial at this time and asking to put this off so we can talk about this more.
Okay. When do you want to try and come back on the 26th or the 9th? What are our numbers on the 26th, Madam Clerk?
I believe that's going to be a heavy docket.
Yeah,
Okay. So you want to look at the 9th?
that's
In
fine,
the
Your
morning?
Honor. Yeah.
Okay, June 9th, we'll come back for June 9th without subpoenas in the morning, 9 o'clock. Ronald Mitchell. Mr. Russell here? Okay. Well, let's pass over that then. Let's pass over Mr. Russell's. Do we have anybody here from Regional Conflict? Oh, Ms. Flowers? I assume you're standing in for Mr. Harper?
I don't know if it shows up on the docket as.
It's Rudisill? I have that one, but that, I don't think that's in, Cobb's not in the queue. Let's see. Who are we bringing up? Rudisill? Curtis Simmons? No, that's wrong. We get the Regional Conflict Council. So we either need to get Fantasy Rudisill and you can bring up Cobb after that. Okay? Those are the two that you have, Ms. Flowers? Or you're not on the other one? Rudisill? Okay. Let's pass on Rudisill. No. Yeah, just pass on Rudisill. Thank you. I just assumed y'all were interchangeable. Ms. Flowers?
Yes, Judge. Thank you. Thank you, Judge, for allowing us to add him to the docket. Jennifer Flowers on behalf of Jasmine Cobb. Your Honor, I have a plea and sentencing agreement score sheet. May I please?
You may. Thank you.
We're here this morning, Your Honor, to enter an early plea in Mr. Cobb's case. He's going to enter a plea of no contest as charged in the information to a withhold of adjudication, $515 in court costs, $100 cost of prosecution, $150 cost of defense, and that all of those costs to be paid within 120 days after his release before being sent to collections.
And the withhold of adjudication is to all three counts?
That's correct, Your Honor.
Yes, Judge.
Okay. Is that correct? Ms. Rivers, that rendition?
Yes, Your Honor.
Okay, and then the score sheet, is the defense in agreement with that?
Yes, Judge.
Okay. Mr. Cobb, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
I just need to ask you a couple questions, make sure you understand kind of what you're doing, and make sure you're in agreement with it. So you heard your attorney state the terms of your plea agreement.
Yes, sir.
And the core of that is that, it'll be court costs and withhold of adjudication on all the three counts, the possession and paraphernalia and providing false name.
Yes, sir.
You understand? Is that what you understand your agreement to be?
Yes, sir.
Okay, I see you've signed the last page of the plea and sentencing agreement. Did you get a chance to go over this plea and sentencing agreement with your attorney? Make sure you had all of your legal questions answered?
Yes, sir.
Okay. And you understand that by entering this plea here today, you're waiving the right to go to a trial?
Yes, sir.
Okay? This will be a final resolution of this matter?
Yes, sir.
Okay. Very good. Do you have any questions concerning this?
sir.
Are you satisfied with the representation of your attorney?
Yes, sir.
Okay, very good. Based upon your testimony, the court will accept your plea as stated by the defense counsel, and all costs will be paid within 120 days, or they'll be sent to collections, and there'll be a withhold of adjudication on all counts.
Yes, sir. Thank
Okay.
you.
Thank you.
Thank you, sir.
Yes, sir.
Thank you, Judge.
Thank you, Ms. Flowers.
Figure out about Mr.
Okay. Okay. Mr. Russell, you want to proceed? You want to start with Ronald Mitchell?
We can, Judge.
Okay.
Charles Russell, Public Defender's Office. Judge, this is Ronald Mitchell. Case number is 22 CF 831.
We're here on a status conference. I think there's some question about kind of how we're proceeding with this matter and where the defendant's going to be housed, is my
Correct.
understanding.
Correct, Judge. It's my understanding that either the jail or the state or both want to send Mr. Mitchell to a DOC facility so he can get proper medical care.
Okay. Is the state in agreement with that?
As to where he goes, Judge? Yes, Your Honor. I don't have a preference to where he goes and stays during the pendency of this case.
And Judge, that's not our request. Like I said,
It's the jail's request.
yes, sir. And I've spoken to Mr. Mitchell about it, and his position is that he feels like he gets better medical care here than he would at DOC. And I can let him address that if the court wants to hear from him.
I mean, I mean, if you have anything you wish to add, I'll be glad to.
Okay. Do you want to swear him in, Judge?
Sure. Sir, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay. You wish to say something to the court about your treatment?
Yes, sir. Okaloosa citizen is the reason I'm blind. So I think Okaloosa should take care of me.
Do you think you'll get better medical care at a Department of Corrections facility or the local county jail?
In prison, they left me suffer for 7 months without being seen. It took 11 days after the incident to go to the emergency room. They restored my eyesight for a week. The eye doctor at the Shands Hospital in Gainesville said, come back in a week. DOC refused to send me back in a week. And my eyesight has declined ever since then. Now I got to go for an eye operation in my other eye that I can barely see out of. I got one eye I can't see out of, and one I can barely see out of. So DOC hasn't done nothing to help me.
Where
And
did
they're
the
reason
injury
why I'm
occur?
blind.
Where did the injury occur?
Okaloosa Correctional Institution.
OCI, Judge.
Which is a DOC facility.
Yes, sir.
Okay. I was a little thrown off when he said the citizens of Okaloosa. As a general rule, the court would house in a DOC facility in situations such as this. They're primarily responsible, and they actually have more resources than the county does. So the court's going to authorize the transport to back to DOC. And if somebody will get me an order, I'll be glad to sign it. They have access to the more resources than we do, even though you may feel that the local government is giving you more assistance at this time. Okay. Anything else from the defense?
No, Your Honor. And this
Okay.
case is set for pretrial on June 29th already.
Okay, very good.
I'd be in touch.
Just go straight in.
Michael Manning.
Charles Russell, Public Defender's Office. Judge, this is Michael Manning. Case number is 21 CF 3237. That is a VOP. At this time, we would go ahead and enter a denial on his VOP. Mr. Manning also has a new law violation, 22 CF 1124, that is currently set for a felony plea day on June the 9th. But the state has already filed an information, so with the permission of the court, we can go ahead and take care of that today if you want to.
Sure.
Yes, Judge. In 22 CF 1124, the state has formally charged Mr. Manning with 1 count of felony petty theft and 1 count of resisting an officer without violence, and that is the new law violation for his violation of probation.
And are you entering a a not guilty on his behalf? Is that what
Excuse
you're
me,
asking
sir, I
the
can't
court to
hear
do?
you.
On the new case, Judge, 22 CF 1124, yes, sir, it's our intention to enter a plea of not guilty, request trial by jury, and 15 days to file any pre-arraignment motions. We would ask that both of Mr. Manning's cases be set to the June 29th pretrial conference.
Very good. We'll set it for June 29th in the pretrial conference.
They weren't willing to accept my offer.
Holly Nielsen.
Charles Russell, Public Defender's Office. Ms. Nielsen is present and approaching. She's on the docket with case number 21 CF 386 and 21 CF 1726. Ms. Nielsen also has a new law violation, 22 CF 996, but that was already null-prossed on 5/16, and I believe that's the basis for the 2 VOPs, so I wasn't sure how we were going to proceed today.
That's correct, Your Honor. The state has filed a null pros on the new law violation, which was the sole basis of her 2 violation of probation cases. So at this time, the state would ask the court to dismiss the violation of probations on both of the cases on the docket today.
Very good. The court will dismiss both of these, both 21 CF 1726 and 21 CF 386, the 2 violations of probation.
And so she'll just go back on probation, Judge?
Yes.
Yes.
Your Honor, she's still on probation until September of 2024 still.
Okay. So just stay in good contact with your probation. You know that. Okay. Okay. Did you get?
Your Honor, I'm ready to handle
Okay, so we'll just go ahead and do Rudicell, Fantasy Rudicell.
Good morning, Your Honor. Jennifer Flowers for Rudy Harper for Fantasy Rudicell. She's here, I believe, today on a violation of probation.
This is, just announce the case for the record, 2020 CF 2459. Go ahead, I'm sorry.
2459. Yes, Your Honor. I believe Ms. Rudicell, we were appointed yesterday on this case, and she also has some new law violations that are already set for June 27th. So I would ask to have this set with the new laws on the 27th.
The 27th or the 29th? I think we should move both of them to the 29th if they were inadvertently, because those are, 29th will be for inmates.
Yes,
so.
Judge, the 29th would be.
Okay, so so we're going to enter a denial here
Enter a
today. So
denial
enter
today.
denial, and we'll come back on June 29th in the morning.
Mr. Hart. Thank you, Your Honor. That's all I
Thank you.
have today.
Thank you. Curtis Simmons.
Charles Russell, Public Defender's Office. Judge, this is Curtis Simmons. Case number is 21 CF 3258. We're here on a violation of probation. At this time, Mr. Simmons is going to enter a denial on the VOP.
Very good. I'll come back on June 9th
That'll work, Judge.
without subpoenas?
Please.
In the morning. Very good. Okay. Thank you very much.
Be in touch, okay?
Stephen Steele.
Charles Russell, Public Defender's Office, Judge. This is Stephen Steele. Case number is 20 CF 331. Mr. Steele is before the court on a violation of probation, and at this time, we're going to enter a denial on the VOP.
June 9th without subpoenas?
Works for us, Judge.
9 a.m., June 9th.
See you later.
James Taylor.
Not today. Maybe. Yeah. Judge, this is James Taylor, case number 18 CF 1688 and 21 CF 592. If we could pass him and call him later on in the docket, State and I are in negotiations. We may be able to work this out today,
Very good.
but we'll call him later.
Okay.
Let me talk to him.
Yes, sir.
Destin Trevino. We'll bring him back right after the break, to give you enough time.
That'll work,
Do those
Judge.
first before you.
Thank you. If I could have a moment, Judge? Judge, we've reached a plea agreement in Mr. Trevino's case, case number 22 CF 597. In exchange for admitting the violation of probation, the state is recommending an adjudication of guilt, revoke and terminate his probation, put him on 18 months community control, waive any cost of supervision, that during the probation, community control, Mr. Trevino would pay a $100 cost of prosecution, $150 PD fee, and then any uncompleted original terms and conditions from his probation would carry over to the community control. May I approach, Your Honor?
That state in agreement with that plea?
That's correct, Your Honor.
And is the defense in agreement on the score sheet?
Yes, Your Honor.
While we're going over this, just this sentence computation, Mr. Russell, would you just kind of, I know where you were going with this, because it's lower, it's a 0, but it's just blank, so I just want to make sure we just put that. So, Mr. Trevino, would you please raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement. Is that your understanding what the plea agreement is?
Sir.
I'm looking at the plea and sentencing agreement that appears to have your signature. Did you go over this plea agreement with your attorney in detail, make sure you had all your questions answered? And you understand that by entering into this, there's going to be a new term of community control. Have you had community control explained to you?
Many people who've been on it. Yes, sir.
It's a significantly higher degree of supervision. This is ramping up. You're getting a plea on this. Do you know what the next step after community control is, don't you?
Prison.
Yeah. I'm just telling you that. I'm not here threatening. I want you to be successful. But in order to do that, you're going to have to pay attention on this community control because, quite frankly, it's not real easy. You can do it, But you got to stay on top of it, stay in contact. In order to do that, it'll end up being good for a number of reasons for you, okay? Okay, but you willing to do that and to participate with that higher level of supervision? And you feel like you've had all your questions answered regarding that? And you understand that by entering this plea agreement, your violation of probation, you're waiving the right to contest it and to go to a hearing and all that. This will be a final resolution of your case. Okay. Have you had all your legal questions answered on this? And do you believe you've gotten good legal representation? Okay, very good. Based upon that testimony, the court will accept your plea and revoke and terminate supervision and institute a new 18-month community control, waive the cost of supervision, and the fees and costs will be paid during the community control.
And Your Honor, the original terms and conditions from the probation?
Yes, do we need to put that in here?
I didn't put the specifics. I put original terms and conditions.
It does say that. Okay, good.
From our perspective, that's fine.
Okay, that's fine. I actually didn't see that, so thank you for pointing it out. Thank you, Ms. Rivers. Barbara Abrams.
Casey Etheridge for Miss Abrams. We're here in 22 CF 210. And we are trying to get Miss Abrams into a program. We still have not gotten an answer, so we're asking to pass this to June 9th.
Your Honor, I talked with Path of Grace, and we're waiting for Eddie to come out and do the interview.
Okay.
So I'm saying we're
Path
still
of Grace is a very good program. I
Yes,
hope
sir.
you can be admitted. So June 9th, if it looks like it's resolved before you can put it on the 26th as well.
Thank you, Your Honor.
So
Thank you.
just be aware of that.
Yeah.
Thank you.
As soon as we can, Your Honor. Thank you.
Sure.
Thank you.
Yep.
We'll put it on right now. We'll continue to June 9th. Jeffrey Ramsey.
Good morning, Your Honor.
Morning.
Jeff Tony for Mr. Ramsey.
Hold on just a second here. Mr. Tony, you may proceed.
May it please the court, I'm sure the court has had an opportunity to review my motion in this particular case. And to the extent that we're here on the motion for a bond reduction, I won't go fully into it, Your Honor, but basically, the purpose of the bond is to ensure the appearance in court. It's not designed to punish the defendant, and is definitely not designed to detain him in custody until the disposition of the case. In this particular matter, there is a $260,000 bond on a third-degree felony. I looked around the state, Your Honor. I tried to find something similar to as it relates to a bond of that magnitude. I could not. This case is an alleged DUI without, and also an infraction for not having on his intake device. This case has not been adjudicated. The $260,000 bond adjudicates this case, and it sets the precedent that there's no way that this defendant can make that amount of money. He doesn't even make that amount of money. He can't pay this bond. In effect, he has no bond at all. He's not a flight risk. He's resided in this community, him and his kids and his family, I know personally, for at least 20-some years. He's no danger to this community. If the court decides that, he shouldn't drive, the court can easily put him on, place a monitor to achieve the same effect that it would. $260,000 clearly is not a reasonable bond, Judge. It is a punishment. At this particular time, we respectfully ask, on the strength of the bond and the factors that are in state, that he be placed with a reasonable bond so he can handle his financial affairs. He supports his family and his kids and his grandkids until this matter can be disposed of.
What are you requesting?
I suggested a bond.
What is the reasonable bond you're requesting?
I think $20,000 would be a reasonable bond, Your Honor. And if the court has safeguards, they can do the monitor that requires no drinking, and also it can restrict his driving privileges.
Counsel for the state.
Yes, Judge. This is Mr. Ramsey's 5th DUI. He's been convicted in Okaloosa County in 2003, 2008, 2021, and he was convicted in Georgia in 2019 of driving under the influence. In the 2021 case, Judge, he pled in front of Judge Ward and was sentenced to probation on May 27th of 2021. He was given 12 months of probation. He was actually on probation when he got pulled over and was arrested for this DUI, to which he blew a .131 and a .128. Another issue in this case is that when he was pulled over, he did not have the ignition interlock on the vehicle, which is required not only as a part of probation, but as an administrative restriction on your driver's license. So based on the fact that Mr. Ramsey has had 4 previous DUIs, 2 of them being within the past 2 years, 1 out of Georgia and 1 out of Okaloosa County. He was on probation for a DUI, and he's trying to avoid the ignition interlock by driving a vehicle that did not have an interlock on it, which is a violation of his driver's license restriction. It's my understanding the bond in the misdemeanor case was revoked because that is a violation of his probation. Based on the fact that Mr. Ramsey's drinking and driving, well, it's a grave concern for the state, for the safety of our citizens, of the community. And the fact that Mr. Ramsey is willing to drive without an ignition interlock tells the state that he's not willing to abide with any conditions that we place on him. Typically, I would ask for a normal DUI case, a scram monitor be placed on someone so that would detect the consumption of alcohol and an ignition interlock to prevent someone from driving. But Mr. Ramsey's proven that he will get around that, and that's a concern for the state. So the state would ask the court, leave the bond set as is, as they are reasonable.
May I respond, Your Honor?
You may.
Your Honor, all that the state has proffered to Your Honor would be of great significance if we were at a disposition of this case. We're not. The state has not given you any facts regarding the arrest because they lead themselves to a possible dismissal. The issue in this case is not what he has done as it relates to those past charges. The issue in this case relates to this particular case and whether or not this bond creates an opportunity for him to be punished or detained.
Can I ask you a question? Is it my understanding, I was a little bit unclear. There's is this a violation of you're saying a violation of probation?
Yes, Your Honor, he has a current violation.
So there's not, the court doesn't have to, you're arguing for a reasonable bond, and I understand why you're arguing for it, but you're not saying, I mean, I'm not bound by any reasonable bond requirement, am I?
Your Honor, the violation of probation is on the misdemeanor case. That matter is, for all intents and purposes, dissolved. We just hadn't had an opportunity to communicate with the state. I've looked at what has been recommended by the probation officer, and they are recommending termination and revoke and terminate, along with time served for a limited amount of days, which I think he's already or close to have conceded. So it would be a matter of just communicating with the state, giving Judge Ward a written plea agreement to that extent, and then that matter would be over. This matter here is clearly about whether or not the bond is reasonable enough to detain him, to make sure that he appears to court. The state has offered nothing to the...
There's also other factors, are there not?
Correct, Your Honor.
And what is the other factor that certainly the court must, and that is the safety of the community?
Correct, Your Honor. And to the extent that the safety of the community becomes an issue, the state has even offered what she would traditionally do in this particular matter, and we concede that. Your Honor could clearly enter his grandmother, monitor, and restrict his driving, his ability to drive, or him even driving a car. That would resolve that issue. However, the $260,000 is tremendous, Your Honor, and it amounts to a punishment, Judge. It says, look, you are guilty of this without a trial. It flies into everything that this legal system is about. It restricts his ability to not only be with his family and even defend this case to the extent that he gets to work and get his finances up. It limits his ability to make a rational decision, because by the time this matter gets resolved, he's going to be in jail, for a few months. He wouldn't have an opportunity to reasonably defend himself. It's restrictive and punishing in nature, Your Honor. It should not be held. I mean, this bond should be restricted to something reasonable.
Give the state the last word.
Judge, given it's his fifth DUI, he's driving down the road with no headlights. He admits to drinking. He admits to leaving JJ's Bar, which is down here in Crestview, downtown Crestview. He admits to drinking. The officer said he had a thick tongue, slurred speech, red, glassy, watery eyes, and the fact that he's driving without an ignition interlock, which he was ordered by the court to do. He is entitled to a bond on this case. Not on the VOP, that bond's revoked, but on this case, he's entitled to a bond that is reasonable given the facts and circumstances, and the state would argue that the $250 on count 1 and the $10,000 on count 2 is absolutely reasonable given the facts and his history.
In normal circumstances, Mr. Tony, the court might be somewhat sympathetic, but the safety of the community is very important, and I'll say one other thing, the safety of your client. Because, Mr. Ramsey, if you continue to engage in this, you're liable to kill somebody, and then you're going to be in here with vehicular homicide. You're going to be facing even worse situations. So I disagree with the counsel on one sense. It's not an adjudication. He has the right to go to trial. This is just holding him until then. So, court, again, I'm somewhat sympathetic, except for the fact that there were 5 DUIs, and this is an extreme danger. The people that are on the road expect that people that are behind the wheel are not drinking and are not going to be a hazard. We've had way too many deaths, even in the last few days, how many deaths we've had on our roads. And so I'm going to deny the request, although in normal circumstances, your arguments would be well taken, Mr. Tony. But in this extreme situation, 5 DUIs is very rare and significant, and it's something that has to be addressed. So the court's going to deny.
Thank you, Your Honor.
Thank you.
Your Honor, this is set for an arraignment on June 9th. The state has filed a formal information.
We've already filed a not guilty plea in the waiver form. We filed everything.
Okay, so you want
Thank
to come back on on pretrial on June 29th? Is that too
That's
soon?
probably, yes, Your Honor.
Okay, so we'll come back for
Let me make sure that thing is.
August 24th.
That's all I have, Your Honor. May I be excused?
You may. Thank you.
Good seeing you, Judge. He didn't change the bond, so I'll do it.
Andrew Richards. No. Yeah, August 24th.
Charles Russell Public Defender's Office. Judge, this is Andrew Richards. Case number is 21 CF 1207 and 22 CF 138. We have filed a bond motion in both cases. The 21 case is a violation of probation. The 22 case are some new charges. He has a bond of $1,000 on the possession of controlled substance in the new case and ROR on the paraphernalia in the new case. He has no bond in his VOP.
The VOP is in the 21 case?
Correct, Judge. My motion sets out what Mr. Richards can testify to. He's been in jail since January 13th, 2022. Mr. Richards thinks he can get employment if the court would give him a reasonable bond. He's lived in this area for 20 years. He resides at 355 Woodyard Road in Defuniak. He's single, but he has 3 kids in the area. He's graduated from high school, and he has not willfully failed to appear in court. So we are asking for an ROR if the court is so inclined.
State, please.
Your Honor, Mr. Richards was pled out to 21 CF 1207 on January 3rd of this year. 10 days later, he was rearrested for the same type of charges: possession of controlled substance, possession of paraphernalia. He scores state prison. His prior arrests and convictions include trafficking in methamphetamines and additional possession cases and even indecent exposure. He's not entitled to a bond, and we believe no bond on his violation of probation is appropriate.
Mr. Russell, I'll give you the last word. Anything further?
Nothing else to add, Judge.
Based upon the total of the circumstances, the court feels that the no bond is appropriate at this time, so the court's going to deny.
And Judge, both of these cases are still set for June 29th, pretrial conference.
Kevin Rogers.
Charles Russell Public Defender's Office. Judge, this is Kevin Rogers. Case number is 22 CF 444. This is a new law violation, and we're asking for a bond reduction in this case. Mr. Rogers is prepared to testify that he's been in jail since February 15th, 2022. He has a current bond of $125,000. He does have a job waiting for him. He's lived in this area for 50 years. He would reside at 5633 Old River Road in Milligan. Mr. Rogers is single, but he has adult children in the area. He's graduated from high school, and he's not failed to appear. Mr. Rogers also wanted to let the court know that he would take care of his mother if he was released. And we, the defense, has reason to believe that the actual victim in this case no longer lives in this area. I don't know if the state's been able to get a hold of her. And Mr. Rogers has some property that he needs to get out to take care of because is it the city or the county? Code enforcement has given him some time to clean up the property, or they're going to start fining him like $250 a day.
Hurricane straps on it.
Okay.
I've got a meeting with him actually. Meeting with code enforcement today at 4 o'clock.
Mr. Rogers indicates that he may lose his property if he's not able to make a reasonable bond.
I've got a meeting with code enforcement today. I've got to put hurricane straps on my trailers.
State?
Judge, the state doesn't have an objection to lowering this bond. The state would still request that it be a cash and professional bond. He does have a significant criminal history involving several batteries, several assault charges, and he has many, many, many violations of probation. He does have some other misdemeanor and felony charges, and he scores 36 months in prison currently. But as long as there is a no-contact order with the victim, if the victim does still reside at the residence, I would ask that there be a one-time opportunity to go with the sheriff's office, and that he not leave Okaloosa County without permission. So the main thing here is no contact with the victim. I don't show any prior failure to appear, so I don't object to lowering the bond, but I would ask that it still be some type of cash professional bond to ensure.
What's the current bond?
125,000. Mr. Rogers does have something else he wants to add, Judge.
I just paid for a $5,000 bond before this, and I paid for a lawyer $8,000. I don't have much money to pay.
So what are you requesting?
I wish I could get a signature bond. I mean, I've got property I can put up for collateral, but I don't have any more cash.
Okay.
Certainly, the state's request for the no contact, is that not contained in the current bond, the no contact?
It should be, Your Honor. I don't have the initial appearance paperwork. It should be, but that would be request.
Pretty
And if he's
standard.
eligible for pretrial services as well. Standard conditions.
The court will reduce it, but I would agree with the state that based on the severity of the charges in the past record, that a $35,000 cash and professional bond would be appropriate. And rest assured, though, Mr. Rogers, if there's any contact with the victim, I mean, and even if the victim tries to initiate it, if there's any contact, you'll be in jail without a bond. Do you understand that? Okay.
And Judge, is
If
it,
she's still residing at the house, you're saying she may be left, you got to stay away. I mean, that's what the original bond said.
except for a one-time trip with law enforcement
Yes.
to get his personal property?
Yes.
Okay,
Okay,
okay. Thank you, Judge.
thank you.
And this case is still set for June 29th.
Okay, very good. Thank you. Okay, so we've got the one other case that you had coming back, and then we've got,
And I have a couple of out of custody.
you do?
Yes, sir.
Okay. Go
Ready to
ahead.
call him? Russell McLaughlin? Charles Russell, Public Defender's Office. Judge, present and approaching is Russell McLaughlin. This is case number 22-CF-628. We had filed a motion to withdraw capias in Mr. McLaughlin's case. If I can get my file. He missed his felony plea day on April the 7th, Judge. The ticket that he had that had his court dates on it had a different date, and that's why he didn't show up. But he did make contact with our office, came in and talked to me and stuff, and so we filed a motion to withdraw the capias for today.
Hey,
Judge, I'll leave it in the discretion of the court. Don't
we'll
see
grant the motion.
worth noting in his criminal history as to failures to appear.
Okay. Very good. Based upon the request, the court will grant the withdrawal of the capias.
Thank you, Judge, and we'll set it for pretrial conference on June 27th.
Yes, that's correct.
Thank you, Judge.
And the state's offer, just so Mr. McLaughlin knows, is an
Do you
adjudication.
have a case, did we announce the case number?
Yes, sir.
Okay.
It's 22-CF-628.
Okay, just want to make sure it's in the court file.
Mr. McLaughlin, your offer to resolve is an adjudication with credit time served and court calls.
I'll be in touch, June. Oh, and my other case, Judge, David Steele. This is David Steele, Judge. The case on the docket is 22 CF 851. We filed a motion to withdraw capias in it. Mr. Steele missed his felony plea day because he was in the hospital. So we filed a motion to withdraw the capias on that case. He has another case pending, but it hasn't come up for court yet, but I want to deal with that after this.
Documentation of the hospital.
He filed some paperwork with the clerk's office. I believe Mr. Steele and his sister filed letters with the clerk.
Judge, after reviewing the medical records provided by defense counsel, it does appear that Mr. Steele was at North Okaloosa Medical Center on Thursday, April 28th. It doesn't have a timestamp on it, but based on the documentation provided, I don't have any objection to withdrawing the capias.
Very good. Based upon the documentation presented, the court will withdraw the capias.
Your Honor, 22 CF 1070 is set for arraignment on May 26th. The state has charged a formal information, if we may go ahead and do the arraignment at this time.
That would be our preference, Judge. That way it'll save him a trip back on May 26th.
What's the case number again for the
22
clerk?
CF 1070.
Okay.
The defendant's been charged with one count of driving while license revoked pursuant to habitual offender and one count of possession of drug paraphernalia.
And at this time, Judge, we'll enter a plea of not guilty to both charges, request trial by jury, and 15 days to file any pre-arraignment motions, and then ask that both of Mr. Steele's cases be set for the pretrial conference on June 27th.
And there's also in 22 CF 851, he failed to appear on the arraignment day, so I'm not sure if defense counsel has already issued a notice of appearance, but we can arraign him on that as well. He was charged in 22 CF 851 with one count of grand theft auto.
And that's correct, Judge. I think what we'll do, we'll go ahead and enter a plea of not guilty on that one for the record, request trial by jury, and 15 days to file any pre-arraignment motions.
The court will enter both not guilty pleas on both of these cases, and both of them will be set for the June 27th, 9 a.m. pretrial.
Thank you, sir. Thank you, Judge.
Thank you. Would the state and Mr. Russell approach? And then we'll take a break. Everybody can get up and move around. Mr. Russell, I think we have one from this morning, earlier.
Yes, sir. James Taylor.
James Taylor.
Judge, this is James Taylor, this is Charles Russell, Public Defender's Office. Before the court is James Taylor on case number 2018 CF 1688 and 21 CF 592. We've reached an agreement with the state. These are both violations of probation. In exchange for an admission of the violation of probation, the sentence is going to be an adjudication of guilt on both charges, revoke and terminate 16.05 months in Department of Corrections, which is what he scores, concurrent credit for any time served, $100 cost of prosecution in each case, $150 PD fee in 18 CF 1688, $100 PD fee in 21 CF 592, and he would get 90 days after his release to pay any money owed or collections. Oh. And Judge, the state's advised me there's also going to be an added cost of transportation payable to OCSO
Yes,
of $89.16.
that's correct.
May I approach, Your Honor?
Mr. Taylor, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
And the state's in agreement,
Yes, Your Honor.
and the defense is in agreement on the score sheet.
Yes, Your Honor.
Mr. Taylor, just a couple of questions. You heard your attorney state the terms of your plea agreement.
Yes, sir.
I'm also looking at a written plea agreement that looks like it has your signature on. Is that your signature? You signed it?
Yes, sir.
Okay, you can put your hand down. So I just want to make sure you went over this with your attorney, made sure you had all your legal questions answered about this plea agreement?
Yes, sir.
Okay. And you understand that by entering into this plea agreement, you're waiving the right to go to an adjudicatory, a trial on these issues. You have a right to do that. You're waiving that right. Do you understand that? And that by entering this will be a final adjudication of this case, and the court will sentence you here in just a second based upon this plea agreement. Is that your understanding?
Yes, sir.
Okay. And you do understand that the probation will be revoked and terminated, so, and you'll be serving 16.05 months in Department of Corrections,
Yes, sir.
credit for time served, but after that, no further probation.
Yes, sir.
Okay. Got a number of costs, et cetera, that'll go to collections 90 days after you get out. You understand that?
Yes, sir.
Okay. Do you have any questions concerning any of this?
No, sir.
Okay. You feel like you've gotten good legal representation?
Yes, sir.
Okay. Based upon that, the court will accept your plea. As stated by your defense counsel, the core of which is 16.05 months in Department of Corrections, as well as the other matters contained in the plea agreement. Okay. Thank you, sir.
Thank you, Judge.
Next case is Jeremiah Murphy.
Tracy Etheridge for Jeremiah Murphy, and we also have Kelly Richards for Mr. Murphy. And Mr. Murphy would be withdrawing his earlier tender plea of not guilty and entering a plea of guilty. I believe the state's going to announce the conditions. May I approach with the plea agreement and the?
You may. Thank you.
Your Honor, this is 18 CF 1558. The state and the defense have reached a resolution in this case. Mr. Murphy will be entering a plea of guilty. He will be adjudicated guilty, sentenced to 40 years in the Department of Corrections pursuant to Florida Statute 775.082, sub 1, sub B 1. He'll be given the credit for time that he's currently served, $515 in court costs, $666.75 cost of prosecution, $100 cost of defense, restitution to the Victim Crime Compensation Fund in the amount of $4,786, and all monetary obligations will be sent to collections. Furthermore, the state and the defense stipulate that the defendant is legally entitled to a review of his sentence after 25 years pursuant to Florida Statute 921.1402 sub 2A because Mr. Murphy was 17 years old. He was a juvenile at the time of the commission of the offense. The defendant, his defense attorneys, and myself stipulate that during the commission of the offense, the defendant actually possessed and discharged a firearm, and as a result of that discharge, did cause the death of Nancy Kirk Williams, and the state and defense have attached that signed stipulation to the plea form. Furthermore, Your Honor, the defendant, his defense attorneys, and myself stipulate that during the commission of the offense, the defendant actually killed Nancy Kirk Williams. That's also contained in the attached stipulated form attached to the plea form. And Mr. Murphy is entering the plea of guilty, so he will be adjudicated guilty. Mr. Murphy and his defense attorneys have agreed to waive the pre-sentence, the PSI, the pre-sentence investigation, and the PSR, the predisposition report, that he would be entitled to if he were a juvenile. Also, Your Honor, we have provided the score sheet, and if you'll notice in the primary offense section, there is no points. Technically, a score sheet does not apply when someone pleads to first-degree premeditated and/or felony murder with a firearm, which is what Mr. Murphy is pleading to. He was charged by indictment by a grand jury of first-degree premeditated and/or felony murder with a firearm, and that is what he's entering his plea to here today. Also, the family is present. They do not wish to make a statement at this time, and I believe the state and the defense agree and stipulate to a factual basis to support the plea.
Yes, we do.
Okay. Would counsel approach? Sure, yes. Okay, Mr. Murphy, I need to ask you a few questions, so I need to swear you in. Would you please raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God? Okay, Mr. Murphy, I'm going to ask you a number of questions. The purpose of this is to make sure that, one, that you have an understanding of this plea agreement here today, and that you're entering it freely and voluntarily. If at any point along the way, anything that is raised by me, any question I have, you have an absolute right to take a step back, ask to speak with either of your attorneys or both of your attorneys, and make sure that you're clear about it. Do you understand that?
Yes, sir.
If you have any questions concerning the questions I'm answering, if you don't understand them, I want you to say, "Oh, I don't understand what you're saying, Judge."
I understand what you're saying.
Okay. So that's kind of the first thing. So you did hear, I assume, and the plea agreement that was outlined by the state. And I also was following along and confirmed that plea agreement and sentencing agreement is contained in your written plea and sentencing agreement. Now, it appears that at the end of that you signed this plea and sentencing agreement. So have you gone over this plea and sentencing agreement in detail with your defense attorneys?
Yes, sir.
And do you feel like you've had all your questions answered concerning this plea agreement?
Yes, sir.
And so let me ask you some very specific things. By entering this plea agreement, and this is contained in your written plea agreement, but I'm going to ask you verbally to make sure, give you any chance, if you have any further questions, you can ask them of your attorneys or ask to speak with them. But I want you to understand that by entering this plea agreement, you're giving up some valuable constitutional rights. Rights as a defense counsel, a defendant that is contained in our Bill of Rights, okay? You're waiving some of those, and I want to make sure you clearly understand that you're waiving those. Obviously, this is a very serious matter. We all don't even have to say that. You understand it as well as the court and everybody else who's probably in this room. You understand that you're waiving the right to a trial by jury or a judge. You understand that? And you have a right during that trial to be represented by legal counsel. You've got legal counsel with you. You have a right in that trial to be represented by legal counsel. You understand you're waiving that right here today. Not the right to your legal counsel, but the right to go to a trial with legal counsel.
Yes, sir.
And you have a right to, at that trial, to compel witnesses. Do you understand that? You're waiving that right. The right to be present when the witnesses testify against you. The right to cross-examine witnesses. You understand you have all those rights are being waived. You have the right to remain silent and not testify against yourself in that trial. But you also have the right to speak up or to present any defenses that you believe are appropriate for you. Do you understand that?
Yes, sir.
You're waiving all those rights. Very good. Importantly, because of, actually by a U.S. Supreme Court case in Miller v. Alabama, they made a ruling that the Eighth Amendment forbids a sentencing scheme that mandates that life in prison without the possibility of parole or for juvenile offenders. That's actually an actual ruling in the U.S. Supreme Court. And that is the basis for the Florida statute that was enacted after that. And that statute, and I'm paraphrasing a little bit, not being precise probably as I could be, but it basically mandates that for first-degree premeditated murder or felony murder with a firearm, that if you're convicted of it, you have a minimum sentence of 40 years. You do. Do you understand what the maximum sentence that you could have gotten if, do you understand that? You actually can get a life in prison. Do you understand that that was a possibility in this?
Yes, sir.
Was that part of your consideration in entering this plea?
Yes, sir.
And so there is the minimum of 40 years, which is essentially what you've agreed to here today, the 40 years, with the very important caveat that after 25 years, and again, this is also required in the statute, that when you have that lengthy sentence, that 40-year sentence, that you must get a review of your sentence after 25 years. You understand that that's part of this?
Yes, sir.
And as part of that, kind of to make sure that statutory process is properly followed, the state and the defense and yourself individually agreed to some special findings, okay? And they're called stipulation, but basically means that everybody agreed to it. But I'm going to ask you to make sure that you're agreeing to this, because you're the person that I'm asking about this. This isn't about your attorneys. So I'm asking you this. One of the findings is that during the commission of the offense, that you, Jeremy Peyton Murphy, actually killed Nancy Kirk Williams. Are you agreeing to that? You agree that that's a factual statement, that that's accurate?
Yes, sir.
And the second stipulation, or the agreement, you're stipulating that during the commission of the offense, you, Jeremy Peyton Murphy, actually possessed and discharged a firearm, and as a result of that discharge, caused the death of Nancy Kirk Williams.
Yes, sir.
Is that a correct statement?
It
I
did,
see that
yes,
you've
sir.
signed, actually. I need to get this signed, counsel. And bring it over there.
Maybe yours was attached to a second one. There's one attached to the plea agreement that is signed. That may have been something you had.
Okay, it's signed. My bad. Thank you.
Sorry.
I was reading off one that was not signed. Okay. So based upon that, and the court is going to be required to make some actual findings that that was stipulated by the state and the defense that the defendant is legally entitled. The court's going to make some written findings on that as well to the review of the sentence after 25 years. That's a part of your plea agreement, but I have to make some separate findings, and based upon the stipulations and based upon your testimony here today, the court's going to also do that as well, to make sure that you do meet the criteria for the review, because you were a juvenile and you essentially get special consideration because you were a juvenile at the time of the commission of this crime. And the U.S. Supreme Court has found that juveniles are different than adults, and so this special accommodation is made. So continuing with my questions, you've had a chance, I'm sure on numerous occasions, to consult with your attorneys. As it relates to this plea agreement and the things that we're talking about here that I'm about ready to sentence you to if I accept this plea agreement, have you had all of your legal questions answered?
Yes, sir.
And are you entering this plea agreement freely and voluntarily?
Yes, sir.
And you have had all of your legal questions answered?
Yes.
Do you believe you've gotten good representation from your attorneys on this case?
Yes.
Do you have any questions of the court about this plea agreement or anything related to your case?
I think you went over everything.
And I'm going to ask you one last question. Why are you entering this plea agreement here today?
Because it's better than life.
You believe the state has the ability to prove their case?
All my defense says yes.
Okay, so you're accepting that based on that is Ms. Gilson? Ms.
Judge, I
Gleason?
just want to add to the record and make sure it's clear, Mr. Murphy understands that the way the statute is written, what he's being sentenced to is referred to a minimum of 40 years, and that is going to be a minimum mandatory 40 years, subject to the review, and that could be day for day, okay, with no gain time. The way the statute is written, that's the way it's interpreted as to be considered a mandatory minimum day for day.
That's a good point. Did you understand what she just said?
Yeah, but I wasn't told that.
You want to talk with your attorney about it more to make sure you are in agreement on that? I think we
Yes.
should do that. Okay. So why don't we just take a short break, and when counsel comes out, if you'll just call me, I'll come right back up. If you'll just call my cell phone. Okay. We'll take a short recess.
All right.
To the attorney-client.
All rise, court is back in session.
Please be seated. Okay. So, Mr. Murphy, you're still under oath. So you've had a chance to speak with your attorneys. Are you wanting to continue? Did that raise any, or did your questions get answered?
Yes, sir.
Okay, so the main thing is, go ahead, counsel.
I think we were wondering.
Sure.
Briefly, Your Honor.
Mr. Murphy, we are going to, everything that we've just been discussing at the bar is on public record, and you'll always get a copy. We're going to reiterate, it's over, the issue is with regards to a statement made by the state regarding the potential or the not potential for getting gain time. So state's going to restate their position on that, and what I want you to do is be listening very closely to this. You've also talked with your attorney about what they think, right? You've talked with them about what their position is on this gain time, right?
Yes, sir.
I want to make sure that you understand what the state's position is and that you're comfortable with this, okay? Okay.
Judge, to clarify the sentence, under statute 775.082, sub 1B1, the defendant is to be sentenced to a minimum of 40 years in the Department of Corrections, with all other costs that were mentioned previously. Ms. Richards has spoken with the Department of Corrections, and the Department of Corrections has informed her that he will be entitled to gain time. I stated earlier that this could be a minimum mandatory sentence, but a minimum mandatory sentence is not to be pronounced for this case. It simply is a minimum sentence of 40 years. The Department of Corrections is in charge of determining if the defendant gets gain time, and if so, how much. So it's all up to the Department of Corrections, and the only thing that we are here for is to sentence him to a minimum of 40 years in the Department of Corrections. There should be no minimum mandatory. Those words should not be included because that's not required by statute.
Okay, so when you earlier said he doesn't get any gain time in this, is day for day,
That's up to the Department of Corrections, Judge. Ms. Richards has confirmed, and they have indicated
you're
that he will be
comfortable
entitled
relying
to-
whatever they say at the Department of Corrections?
Yes, Your Honor.
And just so you understand, Mr. Murphy, that the Department of Corrections is the one who handles the gain time.
I do.
It's not something that we normally address in this, but when it was stated you don't get it, I don't want you to be misled
That's why I
to
asked her.
thinking that there was no gain time or that there was gain time. Your attorneys are telling you they think the Department of Corrections is stating it's ultimately up to them. Do you feel like that needs to be clarified before you can accept a plea, or are you comfortable going forward?
I'm comfortable with it.
You're comfortable going forward?
My questions were answered.
Okay.
Don't mind, this is Kelly Richards for Jeremiah Murphy, and for the record, I did call the Department of Corrections. I spoke with John Becker, and he said it was an easy answer. Depended on when the offense occurred. I told him 2018. He said, depending on Mr. Murphy's behavior, he will be eligible for up to 10 days a month. But of course, that depends on how he does in the facility, and gain time can always be taken away if you get in trouble or have issues, so.
And that will not affect the fact that he's legally entitled to the review at 25 years.
And Your Honor, Kelly Richards again, we've spoken at length with Mr. Murphy. He knows in advance that he's going to be eligible for the review at 25 years. So we've discussed with him how he needs to comport himself and what he might need to show the court after 25 years that he has matured into upstanding, at least has the option of the review hearing at 25 years, and he knows what is to be expected of him. He will be obtaining as many classes and certificates as he's eligible for. And the department has made a shift in their looking at juvenile offenders. They do provide them with opportunities to get trade, to get education, and to even help with employment at a later time. So he's aware of that, and hopefully he's going to do the right thing and live up to what is required of him.
Okay, so Mr. Murphy, does that change anything with regards to your plea?
No, sir.
And just a couple other things. By the way, your attorney mentioned about the education and training. What is your level of education?
I don't have a GED or nothing like that.
What grade did you complete?
11.
11? So, can you read and write?
Yes, sir.
So I'm just asking this because this is kind of a lot of small print and details in this plea and sentencing agreement. I just want to make sure that you understood what it said.
Yes, sir, I do.
Okay. And you do understand that this is, you're waiving the right to request a modification of your sentence within the limits of this agreement, absent a substantial change in circumstances occurring after sentencing? Do you understand that? Have you ever been declared legally incompetent or insane? Okay, very good. Based upon that testimony and the testimony, not the testimony, but the comments of counsel, the court will accept your plea agreement. The court will adjudicate you guilty of the charge, first-degree premeditated and/or felony murder with a firearm, and sentence you to a minimum or to 40 years in the Department of Corrections pursuant to Florida Statute 775.82, 1 in paren, B in paren 1. You will get credit for time served, and there are $515 in court costs, $666.75 cost of prosecution, $100 cost of defense, restitution to the crime compensation, victim crime compensation fund, the amount of $4,786. All monetary obligations will be sent to collections. And the court does find that you are legally entitled to a review of your sentence after 25 years pursuant to Florida Statute 921.1402, 2 in paren, A in paren, because you were a juvenile at the time of the commission of the offense. And the court does accept the stipulations as well regarding the cause of death and the commission of the offense as stated earlier. The court is waiving the pre-sentence report and the PDR. Anything further from the state?
Nothing from the state.
Anything further from the defense?
Sure.
Thank you very much.
Judge.
Does anything, state have anything further for good of the court here this morning?
No, Your Honor.
Thank you very much. Court is now in recess.
All rise, please.
There are a lot of.
88,400.